Hi, hello, good day to all my viewers out there, especially the bar examiners for the forthcoming 2020 and 2021 bar examinations, which will be held on by November of this calendar year 2021. So, kumusta kayong lahat dyan? Sana you are in good health despite the pandemic and the surge of the Delta variant. So just pray that you are in good hands. Uh, of course, we invoke the power of our dear God to always keep us safe from all health hazards and danger. So, in my last video, in my vlog, uh, you have there the schedule of the bar examinations, the 4 Sundays. So that was my introductory video. So this time, my vlog, uh, here in my YouTube channel, Legal Minds. So I do hope you have subscribed, liked, and share to my YouTube channel. So that this channel will grow, and it would be a much help for me, of course. So today I will tackle on some problems which actually I formulated. So these are problems, questions in remedial law. Okay, so remedial law is uh, a hard subject for all to understand, because it consists of procedures and the book is so bulky. Okay, so I think there are more or less 150 rules, okay, or codal provisions in the revised rules of court. So it really takes time for it to understand well. Okay, so but before that, let me have an introductory video. Okay. I go to PowerPoint. So my PowerPoint. So I will open my PowerPoint. So I have my PowerPoint files. Okay, for today's vlog. Okay, I'll drink my coffee. So please allow me to drink my coffee. Okay, just a minute. Oh, okay. Okay. So ayun. Okay. So just wait a little while. Okay, open tayo ng file. Okay, so andyan yung mga file ko. Okay. Okay. Okay, may minimize natin to. Minimize. Okay. Ayan. Okay. So just a little patience. So that's one of the uh, positive attitudes of a barrister. So be patient. Okay. So as you can see here, I have a PowerPoint of my educational accomplishments. So that's me, my name. So that's my law degree. So I attach here the JD because there is a resolution now that graduates of law are now can use the JD or Juris Doctor. Okay, so that this is my undergraduate degree. So bachelor in secondary education, major in mathematics. So I graduated from Leyte Normal University, formerly known as the Leyte State College. So with regards to my graduate studies, so I, with God's will, I was able to finish Masters in Public Management, major in Local Government and Regional Administration from the University of the Philippines, Los Baños, Laguna. So university. Okay. Then my law degree I finished at the Colleges Tacloban City here in Leyte. Okay. So okay, those are some of my files. Okay, we'll open some files. We will open some files. Okay. Okay. Okay, as you can see here, right there you are, my dear barristers. Of course, those viewers who are fond of law or those who are studying law, you can view my blog, Legal Minds. Okay, so let us take a look at the scope of remedial law. Okay, the scope of remedial law or the rules of court, Book 1 pertains to the civil actions, that is Rule 1 up to Rule 71. Okay. Then within that Rule 1 to Rule 71, we have Rule 57 to Rule 61, and these are the provisional remedies. Okay. Rule 57, that is preliminary attachment. Rule 58, preliminary injunction. Okay. Rule 59, receivership. Then Rule 60, replevin. And Rule 61, support pendentility. So we will expound more on this provisional remedies. What are these provisional remedies, and when can you avail those remedies? Okay. Then we have the special civil actions. So these are the provisional remedies. Rule 57 to Rule 61. They are the provisional remedies. So Rule 57 to Rule 61. Okay. Then we have the special civil actions. Okay. So the provisional remedies. Then we have the special civil actions. We have Rule 62, the interpleader. Rule 63, declaratory relief and similar remedies. Rule 64, review of judgment and final orders or resolutions of COMELEC and the Commission on Audit. Then we have Rule 65, certiorari, prohibition and mandamus. Rule 66, quo warranto. Rule 67, expropriation. Rule 68, foreclosure. And Rule 69, partition. So these are special civil actions. Okay. Then as we go on, we have Rule 70, forcible entry and unlawful detainer. So this still belongs to special civil actions. Okay. Just bear with me in my vlog. I hope this can help you, and also this can help me in my aspiration, likewise, to become a lawyer someday, hopefully. Hopefully, God willing, I should have that fire and desire to take the bar, hopefully next year, 2022, God willing. So the procedure in RTC, what are the rules for the procedure in the regional trial court? We have Rule 6 to Rule 39. So Rule 6, from Rule 6 to Rule 39, these are the rules of court for the procedures in RTC. Then for the appeals, for the appeals, Rule 40 to Rule 43 for appeals. Then for the procedure in the Court of Appeals, Rule 44 to Rule 55. And for the procedure in the Supreme Court, Rule 56. So there we are. So we have from Rule 1 to Rule 56. Okay? So that is only for Book 1. Book 1. Okay? Rule 1 up to Rule 71. Okay, 61 for pendentility. Okay. These are special civil actions. Okay. Then we have the special civil actions. Then we have Rule 70, forcible entry and unlawful detainer. Rule 71, contempt. Okay. So this is continuation. Okay. Okay. So this pertains to the procedure in RTC. Okay. Rule 6 to Rule 39 for the appeals, Rule 40 to Rule 43. For the procedures in the Court of Appeals, Rule 44 to Rule 55. And for the procedure in the Supreme Court, it is Rule 56. Okay. So as you can notice, only in Book 1 there are how many articles, how many rules already? 71 rules. That is in Book 1 only. Civil actions. So, it includes the provisional remedies, the special civil actions, okay, and the procedures there. So as you can notice, Book 1, the civil actions already included there, the provisional remedies, okay, and then we have the special civil actions. Okay, so let us talk about the bar examinations. As we all know, the chairman of the 2021 bar examination is the court, Supreme Court Justice Marvikyonen. So this Supreme Court Justice introduced new reforms to the bar examination. Okay, like for example, the reforms. The bar examination is in digital format, and I think there are 2 examiners or 3 examiners per bar subject. Okay, then I think the essay type will still be continued. Okay, the multiple choice type, I don't know if it still be implemented. Okay, because for the 2019, the previous bar examination, the type of examination is essay. So hopefully in the 2020 to 2021 bar examinations, it will be essay type. Okay, so I think it is advantageous for the bar examinees if the questions are of the easy type. Why? Because in your answer, if you write an answer, okay, you will get 5 points if it is 5 points in case you get the correct answer. Okay, now how do you answer? What is your style of answering essay questions? So we have the so-called ALAC, the ALAC method. So okay, may I write it? May I write it? Allow me to write. Okay. Okay, so the ALAC method. So what is the ALAC method? ALAC method. So ALAC method. So A for You know this. A uh, for your direct answer, whether it's a yes or a no. Okay, so if the question calls for an answer of a mere yes or no, so do not answer anything that will confuse the minds of the examiners. Okay, so answer directly if it is a yes or if it is a no. Do not say it depends. Okay, then B, so that is the L, the alak. Okay, you state the legal basis. Okay, legal basis. Okay, why did you say yes and why did you say no? Okay, why did you say yes and why no? Why did you say yes or why did you say no? Okay, so in here, in the alak method, so the legal basis, of course, you cannot memorize all the codal provisions. So you just say under the law, okay? Or if it is a case law, under a case law, okay? Or say a jurisprudence, okay? Under a jurisprudence, okay? You can state that in that way. Okay? Then we have C. Okay. C. We have application. So you will state the case. Okay. So you will say in the instant case or in the case at bar. Okay, in the instant case. So this is the keyword. In the instant case, that is the keyword you are going to use. Then you state the case. Okay, then apply your legal provision. Okay, apply the legal provision here in the application. Then we have the alak method C, that is conclusion. Okay, so you will say here the keyword here is thus. Okay, okay. So you have 4 short paragraphs using the alak method. So that is how you are going to answer bar examination questions. Okay, so that is alak method. All right. So bear with me, my dear viewers. Okay. Actually, I am using the Freeloom app. Okay. So alak method. So A, your direct answer, yeah, whether a yes or a no. Okay. Because most questions in the bar examination call for a yes or a no answer. Then do not stop by just writing a yes or a no. make an explanation why yes and why no. So that is now your legal basis. Why did you say yes or why did you say no? Then you will apply that legal basis in the instant case. Okay? You will apply. Then your conclusion. Okay? So there you are, my dear viewers. So that is the ALAC method. Okay. So I think I will add. So is it just okay for you if I will give illustrative examples? So I formulated some questions in remedial law pertaining to evidence. So evidence is book 4 of remedial law. Okay. Okay. Okay, we will open another file. Scope. We'll open. Okay, we have here the remedial law, the rules of court scope. Okay, we have book 1 civil actions, that is rule 1 to rule 71. Okay, rule 1 to rule 71. Then book 2 we have the special proceedings, that is rule 72 to rule 109, rule 109 for the special proceedings. Okay, then we have book 3. Okay, we have the criminal procedure, rule 110 to rule 127. Then we have book 4. Okay, book 4 we have the evidence or rules of evidence, rule 128 to rule 134. Then we still have book 5, that is rule 135 to rule 144. So this is the scope of remedial law. So civil actions, special proceedings, criminal procedure, then we have evidence. Okay. Now in civil actions, included there are the provisional remedies and the special civil actions, and then the procedures in the Court of Appeals. Okay, the appeals, procedure in the Court of Appeals, the procedure in the Supreme Court, included here in book 1. Okay, so there we are. Let's see what my files are. Okay, remedial law, rules of court. Let's try to open this. Okay, that's the rules of court, ALAC method, scope, possible questions. Okay, so I have here the revised penal code of the Philippines. So this is for the criminal law. So we all know that book 1 is crimes in general, then book 2 crimes and their penalties. Okay, so if we are for a civil code, we are after the civil code. Okay, allow me to have this civil code of the Philippines. So book 1, we know it is persons, and family relations. Okay, so here in book 1, the most important resource here is the Family Code of the Philippines. Okay, the Family Code of the Philippines. Family Code of the Philippines. Okay. Then we have book 2. So in civil code, what do you think is book 2? Okay, I think it is property, if I am not mistaken. Okay. Book 2, property. Okay, book 3. Okay. Okay, so in my another video, I'm going to take it up, the books of the Civil Code of the Philippines. Okay. Then in commercial law, we also have in commercial law different books. Okay, in commercial law. Okay, so this is the scope of the remedial law, book 1, book 2, book 3, book 4, then we have book 5. Okay, so let us see in my files. Remedial law, rules of court, scope 2, ALAC method, the scope of remedial law, educational accomplishments. So I have here the grounds for motion to dismiss in civil actions. Okay. Okay, let us open na lang this one. Okay. This one, let us open. Okay. 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 We have Rule 45 and Rule 65. Okay? Distinguish between Rule 45, certiorari as mode of appeal, and Rule 65, certiorari as original action. So, what is the difference between Rule 45 and Rule 65? So here, Rule 45 or certiorari as mode of appeal is the remedy of the defendant for errors of law of the lower court. So when it is errors of law, when there are errors of law, okay, pronounced by the lower court, so the defendant could avail of the remedy of Rule 45, I mean, that is certiorari as mode of appeal. Okay, so that when the court has errors of law in the decision, okay, so Rule 45 will be the mode of appeal. So this is the available remedy for the defendant. Okay. While on the other hand, the Rule 65 speaks of certiorari as an original action. Okay, when can the defendant avail Rule 65. So this remedy can be availed when the trial court lacks or in excess of jurisdiction. Okay? The lower court exercised a lack of jurisdiction, in excess of jurisdiction, or the lower court exercised grave abuse of discretion. Okay? So that is the distinction between Rule 45 and Rule 65. So in Rule 45, that is certiorari as a mode of appeal. Then in Rule 65, certiorari as original action. Okay, hope you get something from this. Okay, it might be asked in the bar examination. The Rule 45 and the Rule 65, the certiorari as a mode of appeal, and Rule 65, certiorari as original action. Okay, let us come to other concerns. Grounds for motion to dismiss. This one. Okay. So what are the grounds? What are the grounds for motion to dismiss a complaint? So there are 12 grounds all in all. So there are 12 grounds. So a complaint. So this is in civil procedure. Okay. Complaint for a civil action. So that falls under civil procedure. So you will dismiss a complaint. Your lawyer can move to dismiss a complaint on the following grounds. Okay. So, what are the grounds for motion to dismiss a complaint? So, just wait for a while. So, one, that the court has no jurisdiction over the person, the defendant, or over the subject of the action or suit. Okay, over the subject. Okay, so here the court has no jurisdiction over the person of the defendant or over the subject of the action or suit. Okay, so that will be a ground for motion to dismiss. Okay. Another, that the court has no jurisdiction over the nature of the action or suit. Okay. So later on, we will have illustrative examples for this in my subsequent videos. Then, that venue is improperly laid. Okay. So that can be a ground for motion to dismiss a complaint. Another is that the plaintiff has no legal capacity to sue. No legal capacity to sue. Another, that the cause of action is barred by a prior judgment or by statute of limitations. Okay. The cause of action barred by a prior judgment. Okay. So there was already a judgment, a prior judgment for the same cause of action. So, or the cause of action is barred by the statute of limitations. So that can be a ground for dismissal. Okay. Then another, that the complaint states no cause of action. Okay. So this is a defect of the complaint. So if there is no cause of action, so there is no need for litigating. Okay? There's no need for litigation. I mean, if there is no cause of action in the complaint. So, in other words, that the complaint is moot and academic. If there is no cause of action, so what is to be litigated? So the lawyer can move for dismissal. Another ground for motion to dismiss, that there is another action pending between the same parties for the same cause. Okay, this is self-explanatory. Of course, if you have another action pending in the court involving same parties and involving the same cause of action, then the lawyer of the defendant can move for dismissal. So another ground, that the claim or demand in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished. Okay? So likewise, the lawyer here can move for dismissal. The claim has already been paid, the claim has been waived, the claim has been abandoned, okay, or otherwise the claim has been extinguished. Okay, so these are grounds for dismissal of the case. Okay, dismissal of the case. Why? Because the claim been paid already, the claim been waived, the claim has been abandoned, and the claim has been extinguished. Okay, so the lawyer of the defendant can move for dismissal of the case. And then another is that the claim on which the action or suit is founded is unenforceable under the statute of frauds. So we have here the statute of frauds. Okay, so we will tackle this in our civil law, statute of frauds. We have a statute of limitations, a statute of frauds. So here, the claim on which the action or suit is founded is unenforceable under the statute of frauds. Okay, so that is the 9th ground for dismissal. Then the 10th, that the suit is between members of the same family. So and no earnest efforts towards a compromise has been made. So kung mga kapamilya lang yung lilitis-litis, sila lang yung mga parties, members of the same family, like for example brothers and sisters, son and parent, so you can move for dismissal. Much more if there have been no compromise made. Okay, you can move for dismissal in that situation. Then the 11th, failure to exhaust administrative remedies. So kung hindi pa na yung administrative remedies exhausted, and then nag-file ka agad ng kaso sa korte, then your lawyer can move for dismissal. Okay? So that is a ground for dismissal. Then the last one, failure to comply with LGC 1991 on barangay conciliation. Okay, so this one is very important. Okay, so before filing a case in court, it should comply first with the LGC 1991 on barangay conciliation. Okay, okay, if this has not been utilized, the LGC 1991 on barangay conciliation, then your attorney can move for dismissal of the complaint. Okay. So that one, motion to dismiss a complaint. Then this is in civil procedure. Okay, complaint. If you have a civil case, so this would be your remedy: dismiss, move for a motion to dismiss the complaint on those 12 grounds. Okay, then we have in criminal procedure, we have the motion to quash. So if you have a case, a criminal case, okay, your remedy would be motion to quash. So motion to dismiss in civil procedure, then motion to quash in criminal procedure. So there are 8 grounds. Okay, there are 8 grounds for the motion to quash an information. Okay, so what are these grounds? That the facts charged do not constitute an offense. Okay, so the facts charged do not constitute an offense. So the defendant's lawyer can move to quash. Okay, the information. If the facts charged do not constitute an offense. Then, second, that the court trying the case has no jurisdiction over the offense charge or the person of the accused. So yung trial court walang jurisdiction sa paglilitis. Okay? Para sa krimen o para sa person of the accused. Okay? Then, pangatlo, that the person who filed the information has no authority to do so. Okay? So the one who filed the information has no authority to do so. Okay? For example, in rape cases, so if you are not the one directly affected, then you cannot be the right person to file the case. Okay. Then, fourth, that it does not conform substantially to the prescribed form. Okay, the form, there is a prescribed form. Okay. If the information does not conform to the prescribed form, then it can be a ground for quashing. Okay, so the term here is quash in criminal procedure, but in civil procedure it is motion to dismiss. In criminal procedure, that is motion to quash. Okay, another ground for motion to quash, that it does not, okay, that more than one offense is charged, except in those cases in which existing laws prescribes a single punishment for various offenses. So kung madami ng krimen ang itinacharge sa information, then can be a ground for motion to quash. Okay? Pero may exception. Okay? Except in those cases in which existing laws prescribes a single punishment for various offenses. So that is the exception. Then another ground for motion to quash, that the criminal action or liability has been extinguished. Okay? So extinguished na yung criminal action or liability. Okay? So if it is already extinguished, then there is no reason for filing an information. So the lawyer can move for a motion to quash. Then next, that it contains averments which, if true, would constitute a legal excuse or justification. So marami na yung mga averments sa information which would constitute a legal excuse or justification. Yun bang parang para maka-excuse lang. Okay. May marami ng mga averments. So the lawyer can move for a motion to quash. Then the last one, that the accused has been previously convicted or in jeopardy of being convicted or acquitted of the offense charged. So dito na yung double jeopardy. So pag previously convicted na yung accused, then he has served already the sentence, then it's now moot an academic for filing a criminal action against him. Okay? So that can be a motion to quash. Okay, so there we are, my dear barristers, especially those who will take the bar examinations this 2021 November. Okay? Marami-rami din ang titik ngayon. Kasi yung mga 2020 candidates, okay, 2 batches of aspiring lawyers. So those who finished in the year 2020 and in the current year 2021, okay, so they will be taking up the 2021 bar examinations. So ingat kayo, and sana marami yung makapasa sa bar examination na ito. Okay? So in my case, due to circumstances, so I cannot take meantime the examination. I do hope I have that much time and financial capability next year to be able to take the bar. Hopefully, God willing, sana i-grant na ni Lord. Okay? So another changes to our current bar examination system. So aside from being digitalized, the bar applicants should have been vaccinated, fully vaccinated by the COVID-19 vaccine. So that is one of the requirements. Full vaccination sa COVID-19. So hopefully sa next year wala nang COVID, para wala nang vaccination so that those, though they are not vaccinated, they will be able to take the bar examination. So hopefully next year, okay, hopefully the bar chief examiner will amend this requirement on COVID-19 vaccination. Okay, so that's it, and more in my upcoming videos. And by the way, please don't forget to subscribe to my channel, Legal Minds, and please don't forget likewise to like and of course share. And bye bye.